Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about why it's a terrible idea to have a joint bank account holder that's not your spouse. Before we get into that, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, I had a call with a potential client yesterday who was looking for some advice related to probate. They had lost a loved one and they were trying to figure out how to take care of a surviving spouse. And what happened is the person that died had a child on the account with them as a joint account holder. The surviving spouse was the step parent of the decedent, the person that died. They were having trouble because the person died, because it was a joint account. The joint account holder now becomes the total account holder. So the assets with the money in it, the bank account with the money in it, went to the child instead of being available for the surviving spouse, even though that is what everybody anticipated doing. And actually, thankfully, in this context, this time, there wasn't a lot of sort of bad behavior going on necessarily, but it still created a very sticky situation where stepmom is having to reach out to stepchild to get money to live off of, basically. So when you have joint account holders, when one person dies, the other person automatically gets that money. And while this might seem like a good idea in practice, in reality, it causes a lot of different problems because the joint account holder also has the ability to withdraw those funds at any time. The joint account holder can put those funds subject to creditors like bankruptcy or lawsuits. The best solution, if you want to make sure that someone gets your account when you are gone, is to use a transfer on death designation. The best solution, if you want someone to be able to help you manage the account, is a power of attorney, okay? Not joint account holder. If you have a surviving spouse or if you have a spouse, joint accounts are preferable in many cases. But other than that, don't use a joint account holder. Okay, that's it. That's my lesson for the day. If you have questions about this or anything else, as always, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. That's it for today. Thank you for your time. I'm Christopher Small, by the way, as always. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.